Nehad S. Abdelnabi versus State of Tennessee.
Thank you. Mr. Isaacs, go ahead.
Good afternoon. May it please the court, I'm Gregory Isaacs and I represent Nehad Abdelnabi. The basis for our appeal is very fundamental, and that is a juror was not impartial and failed to disclose relevant information during voir dire, depriving the petitioner of a fair trial. It is well established that the gatekeeper, the gateway to a fair and impartial jury is a process that enables counsel to impanel an impartial jury through questions that present the intelligent exercise of challenges by counsel. We rely on State versus Adkins. In this case, this is significant. In the voir dire process, silence and failing to disclose is tantamount to a false disclosure. When there is a reasonable question of a material issue, it gives rise to a presumption of bias and partiality, and that is what we have in the instant case, and we would further rely on Faulkner versus State. First and foremost, the juror, Ms. Roberts, failed to disclose her relationship with the District Attorney, Sharm Allen. This was extremely significant. Ms. Roberts was a self-described campaign manager who had met Ms. Allen through her campaign. She acknowledged that she had assisted Ms. Allen during that campaign process. There is information in the record that she had worked the polls for Ms. Allen at the election, that she had helped set up a campaign table at the Lincoln Day dinner, that she had conversations with Ms. Allen about the appearance of her husband, Kevin Allen, who was trying the case, District Attorney Allen, and that she had waved at Assistant District Attorney Allen prior to the beginning of the trial. What is extraordinarily significant, on at least 3 occasions, the court inquired as to whether anyone knew any of the parties. That occurred at the beginning of the voir dire process. It occurred when jurors were excused. It also occurred when the alternates were selected. And in this case, there is a benchmark for how a reasonable juror should have reacted, and that is Juror D'Angelo. And during the process, after hearing the colloquy from the trial court, from Judge Sword, Mr. D'Angelo raised his hand and informed counsel and the court that his son does play baseball with District Attorney Allen's son and Assistant District Attorney Kevin Allen's stepson. They approached the bench. There was a motion made to strike Mr. D'Angelo for cause, and that was granted by the trial court, and Mr. D'Angelo was dismissed. At the PCR hearing, it's important to note that Ms. Roberts denied she knew D.A. Allen personally, but admitted knowing her through the Republican Party. However, her ex-husband, Mr. Coleman, who is central throughout the post-conviction hearing, painted a much different picture. Mr. Coleman stated they were friends, stated that she had directly assisted Ms. Allen, had made jokes about, again, the appearance of Kevin Allen to her during the trial. Clearly, that is something that a reasonable defense lawyer would have pursued and most likely would have interjected an objection to strike Ms. Roberts for cause. When you compare that to the forthcoming disclosure of Mr. D'Angelo, in addition to the fact that Judge Sword struck D'Angelo for cause, it goes to show that her failure to disclose did impact negatively the right for Mr. Abdelnabi to have a fair and impartial jury. And it continues with Ms. Roberts. The juror was also prejudiced towards Islam and Muslim men. The voir dire in this case was very specific regarding the issue of the Muslim faith and Muslim men. There was extensive questions by the defense counsel and by the state, Mr. Allen, about that issue, about the Muslim faith, about issues regarding immigration. So both sides noted that that was going to be a hot button topic, that they needed to seat someone that was a jury that was fair, impartial, and not biased as it related to any issues with race or color. Mr. Coleman, again, the ex-husband of Ms. Roberts, testified in very significant detail about Ms. Roberts' feelings as it related to Muslim men and men of that ethnicity. Coleman stated that she had referred to individuals of that faith as towelheads. She had made many other disparaging references toward him. She had made disparaging comments regarding Mr. Abdelnabi. She had also said that she believed, and this is important, Muslim men subjugate their wives and use the term towelhead to refer to followers of Islam. And that is Mr. Coleman's testimony on page 33 to 35. You know, this was an aggravated kidnapping case, especially aggravated kidnapping case with Mr. Abdelnabi's wife. These were very significant issues. And our U.S. Supreme Court in Pena Rodriguez versus Colorado clearly drew a bright line test when they said that the fundamental part of the jury is to be a criminal defendant's fundamental protection of life and liberty against race, color, and prejudice. And in this case, the issue of Mr. Abdelnabi's ethnic origin, his faith clearly was very central to both the prosecution and defense, and questions were asked repeatedly. And once again, this stealth juror, Ms. Roberts, failed to make a disclosure as required. Additionally, Ms. Roberts did not disclose her prior victimization. Ms. Roberts did not reveal she had been a victim of domestic abuse. Judge Sword, in his order, indicated that he didn't recall anyone asking if they had been the victim of a crime, but a careful review of the transcript of voir dire indicated that the jury was asked if they have ever been the victim of violence, and that is in the record at Exhibit 1, page 29. Mr. Coleman testified that in her prior marriage, she was married to an ex-Marine, and that she had, quote, spent her entire marriage hiding in a closet and was afraid of being abused by her husband. Mr. Roberts went on to say that he personally witnessed acts of violence when he went to retrieve her belongings from the house of the ex-husband, that the ex-husband attempted to punch Miss Roberts, the juror, and was stopped by Mr. Coleman. You know, once again, in a case involving significant and severe domestic violence, this juror chose not to disclose that she had clearly been victimized. And as we continue, I think what is significant, Judge Sword indicated during the course of his opinion that the statements of Mr. Coleman, the ex-husband, were being introduced, or well, being admitted not as substantive evidence, but prior inconsistent statements under 803.26. However, the totality of Mr. Coleman's testimony clearly shows that this individual was being non-responsive, wanted to be a stealth juror and did not allow trial counsel an open opportunity to have a meaningful voir dire. Also, regarding Ms. Roberts, she used, according to Mr. Coleman, her phone to obtain extraneous information during the course of the trial. Clearly, Tennessee courts have said that trial courts should clearly prohibit jurors' use of devices such as smartphones, tablet computers to access social media. State versus Smith. In Adams, our court said that when a jury has been subject to either extraneous or prejudicial information or outside influence, that it calls into validity of the verdict. And this issue is, again, it's like a coral reef with Ms. Roberts. At the PCR hearing, now this is something where she denied that she had used a computer or her cell phone to do legal research, et cetera, in violation of Judge Sword's admonition. But she was asked if she ever told another district attorney who had this case and then mysteriously parachuted out, did you ever do research on your phone? And she replied, I think the wording I used with him is that something I could have done. Transcript at 28 and page 29. The state, importantly, did not call ADA Sanchez to rebut Roberts' testimony. Again, Mr. Coleman said she was fascinated with the trial, fascinated with legal research. But what's interesting, if you are in a serious felony trial and the judge admonishes you not to use extraneous outside sources, and your response is, I think that's something I could have done. Clearly, that should have been viewed in the totality of her other failure to disclose issues as evidence of her partiality and her bias.
Let me interrupt you just 1 minute. She testified at the post-conviction hearing, obviously based on that statement that you made. Didn't she refute everything else her ex-husband testified to?
She admitted to be very involved in the Republican Party, admitted to having a relationship, but not a friendship, with the district attorney, Sharm Allen. So she did corroborate parts of Mr. Coleman's testimony, but the most on point and direct admission by Ms. Roberts was her testimony that she could have researched legal issues on her phone.
I thought the post-conviction court made some findings that Mr. Coleman was not credible with regard to much of his testimony.
Well, and conversely, in terms of letting these statements in under 803.26, there had to be a credibility issue vis-a-vis Ms. Roberts and vis-a-vis Mr. Coleman. But I don't think there was anything in the record that really impeached Mr. Coleman. And, again, I think the fact that Mr. D'Angelo, who played baseball with District Attorney Sharm Allen and Assistant District Attorney Kevin Allen's son, and because of that limited relationship, Judge Sword issued struck Mr. D'Angelo for cause at the bench. If Ms. Roberts had disclosed this information during voir dire, it would have allowed defense counsel the opportunity to voir dire, to follow up on questions. So did she deny it? Yes. She did not deny doing the legal research on her phone, and the district attorney's office switched lawyers. I think when you look at the totality of that, it clearly shows that there is an inference that she was biased and partial and wanted to be on this jury based on her relationship with Ms. Allen as a Republican candidate. And I think it's also interesting, when there's a credibility determination, it would be hard to fashion that this individual had set up a table at a Lincoln Day dinner, had worked the polls for Ms. Allen, had done all this work, and had not had a relationship. And clearly that relationship would have exceeded the quantitative and qualitative relationship of Mr. D'Angelo, when there was clearly a finding by Judge Sword that created a impression of bias and impartiality. So Did she deny what Coleman said by and large? Yes, with the exception of the legal research. But should she have disclosed under Smith, Adams, Faulkner? Yes.
Thanks. You answered my question.
Okay. And I think I've utilized my time. So unless there's a further question, I will reserve the rest of my time for rebuttal.
Thank you. All right, General Ward.
Good afternoon, Your Honors. May it please the court. My name is Garrett Ward. On behalf of the state in the matter of Nehad Abdelnabi versus State of Tennessee. Your Honors, petitioner describes this case as a case of a shadow juror. His claim for post-conviction relief is premised on a number of allegations about a juror, Michaela Roberts. He alleges that she engaged in a number of behaviors that jurors in Tennessee courts are prohibited from engaging in. What this case really comes down to, Your Honors, is whether or not the post-conviction court, who heard the testimony of Ms. Roberts about the allegations raised by petitioner, and then heard the testimony of her ex-husband, Mr. Coleman, who raised these allegations. The question is, which one of these two witnesses at the post-conviction hearing was accredited by the post-conviction court? And what this court will see today during, as I'll outline during my oral argument, and when this court examines the record, that time and again, the post-conviction court accredits the testimony of Ms. Roberts above that of Mr. Coleman. Tennessee post-conviction law is clear that on these sorts of credibility determinations for witnesses at post-conviction hearings, they're best made by the post-conviction court, and that these determinations are do a great amount of deference here before this court on appeal. And that's really what this case comes down to, is the credibility of these two parties. I'll address sort of in the same order petitioner did the specific allegations. First, the petitioner suggests that during voir dire, that Ms. Roberts concealed the nature of her relationship with ADA Kevin Allen and elected district attorney Charm Allen. Your Honors, there were questions during voir dire about whether any juror had prior encounters with ADA and DA Allen during previous cases that would affect their ability to hear the case at issue. There were also questions about whether or not there were specific relationships between the jurors and ADA and DA Allen. During these questions, Ms. Roberts did not volunteer any information. When asked why, though, at the post-conviction hearing, Ms. Roberts offers a view of her sort of knowledge of ADA and DA Allen as largely being tangential. Essentially, Ms. Roberts' testimony is that, yes, I volunteered with the Knox County Republican Party. I volunteered with some campaigns. Occasionally, was a poll worker. Set up some fundraising events. This is certainly the sort of civic activity that Ms. Roberts was allowed to participate in. Her testimony specifically, though, as to Charm Allen, is that she really only knows her as a political figure, that she knows General Allen as a part of the Republican Party, and that her knowledge of General Allen is to the same extent that any Republican in Knox County knows General Allen, that she's a figure that runs for elected office. So she knows, her testimony is that she knows Charm Allen sort of to that extent and that extent only. That's her testimony at the post-conviction hearing. By contrast, as opposing counsel outlined, Mr. Coleman testified as to a personal relationship between Juror Roberts and General Allen. Testified as to Juror Roberts joking with General Allen about ADA Kevin Allen's appearance during trial. These sort of specific allegations are denied by Ms. Roberts and are inconsistent with her testimony. So what the trial court has to do here, in the face of this very personal relationship alleged by Mr. Coleman and this sort of passing knowledge simply due to political affiliation testified to by Ms. Roberts, the trial court has to make a credibility determination. And Judge Ayers, as you noted earlier, when the trial court or when the post-conviction court makes these determinations in this case, it consistently accredits the testimony of Ms. Roberts over that of Mr. Coleman. It's important to note that when the trial court's making this credibility determination, it's basing this based on its ability to see these two witnesses. These two witnesses appeared before the post-conviction court, meaning it's sort of uniquely situated to make a credibility determination in this case. And it has full knowledge of their circumstances. Juror Roberts and Mr. Coleman were formerly married. There are portions of the record that suggests the split between the two of them was at least somewhat contentious. So based on its knowledge of their circumstance and its ability to personally observe both of these witnesses, the trial court made a credibility determination on this fact, on these relationships, about whether it was passing knowledge because of political involvement or a personal friendship. And the trial court here accredited Ms. Roberts' testimony. And based on the trial court's accreditation of her testimony, that forecloses a finding that she was deceitful or concealed information about her relationship during voir dire. I would like to briefly address this suggestion that Ms. Roberts and a juror who was eventually removed from the jury, Jury D'Angelo, are essentially in the exact same position. What occurred with Mr. D'Angelo is that when he was asked, when Juror D'Angelo was asked during voir dire if he knew or recognized ADA Kevin Allen, he responded that he did, that his son and ADA Allen's played baseball together. Based on this answer, there was a sort of a bench conference where ADA Allen, Mr. Abdelnabi's attorney, and Mr. D'Angelo discussed this relationship. Mr. D'Angelo indicated that it really would have no bearing on his ability to try this case. And a cause challenge was initially denied by the trial court. And then ADA Allen offered to the trial court, well, now that I see him, now that I get a closer look at him, I think his son has probably stayed over at our house a time or two because of this baseball team involvement. And it's with this additional information that the trial court ultimately strikes Juror D'Angelo. By contrast, Your Honors, when Ms. Roberts is asked about ADA Kevin Allen during voir dire, she says that she doesn't know him. During the post-conviction hearing, when she's asked about this, asked about her knowledge of Kevin Allen, what she reveals is that she sort of realizes who he is after trial is over because she comes to understand that he's the husband of Charm Allen, and she, as I detailed to this court, has knowledge of Charm Allen due to her political involvement. So I believe, Your Honors, what the record reveals here is not any sort of conceit or concealment by Ms. Roberts. What the record reveals is that she had sort of a passing relationship with General Allen due to political involvement. and it didn't rise to the level of any personal connection or friendship, and that her relationship and knowledge to 88 Kevin Allen is so passing and so surface level that she doesn't even recognize him, that it's not until after trial when she sees him with this other person who she has some knowledge of due to her political involvement that she for the first time comes to have some understanding of who 88 Allen is. And based on all of this, Your Honors, the trial court was certainly well entitled to accredit Ms. Roberts' testimony above that of her ex-husband's, and the trial court's credibility determinations here are different.
Does the state accept the proposition that the attack on the partiality of this juror can be raised here as a freestanding issue?
I believe it's a close call in this case, Your Honor. It is sort of premised on the freestanding issue here is premised on sort of a discovery of juror bias that arose after trial. What the record reflects is that it's during post-conviction that Mr. Coleman is sort of first spoken to by
Was
post-conviction.
it raised after the motion for new trial was heard or before that?
It's after, Your Honor. It's sort of during the post-conviction process that juror Coleman information first comes to light.
Okay. Thank you.
Turning to the next allegation about bias, and this will hit on the theme that is common in this case. We have a situation where Mr. Coleman makes some pretty concerning allegations about his ex-wife's beliefs. He suggests that she used ethnic and racial slurs to refer to the defendant, that she harbored negative beliefs about men of the Muslim faith and the way they would treat the women in their lives. That's the testimony of Mr. Coleman. The testimony of juror Roberts is to the contrary, that she did not have any of these beliefs, that she had no bias against men of the Muslim faith, that she did not use any ethnic slurs to refer to the defendant. We have simply put a clear case of competing testimony between two witnesses. With the previous issue, the trial court or the post-conviction court accredits the testimony of juror Roberts above that of her ex-husband. That determination is due deference by this court, and yet again forecloses relief on this claim. There's no credible proof, as the trial court says. There's no credible proof that any of these sort of salacious or inflammatory beliefs were actually possessed by this juror. A similar story arises when it comes to this allegation that Ms. Roberts was the victim of a prior crime. It is true, Your Honors, that there was a question that somewhat touched on violence during voir dire. On page 29 of Exhibit 1, which is the voir dire transcript, the jurors are asked if they, and I quote, had ever experienced a significantly traumatic event where you have been beaten pretty seriously. That is the question that the jurors are asked in this case. There is no sort of, as petitioner seems to suggest, there is no broad question about sort of a more loosely defined, a less serious version of being a victim of a crime or being a victim of violence. And there's certainly no suggestion in the record through any credible testimony that there was an event in Ms. Roberts' life that would cause her to believe that she experienced significant trauma by being beaten very seriously. She denies that occurring. So as I suggest, just based on the question actually asked, there's no evidence in this record to suggest that Ms. Roberts responded to it in a deceitful manner. However, even if we were to read this question, which again is, have you experienced a significantly traumatic event where you've been beaten pretty seriously? Even if we're to read that question as perhaps probing the veneer about more incidental, less serious encounters with the criminal justice system or with crimes of violence, Ms. Roberts denies having any such experience. She outrightly denies at the post-conviction hearing that she has been the victim of any crime, and specifically denies being the victim of domestic violence. The testimony that she was the victim of domestic violence again comes from her ex-husband. He testifies that in a previous marriage, she suffered domestic violence. Ms. Roberts testifies to the opposite. So yet again, as with the other issues in this case, the trial court has two witnesses. It must make a credibility determination between the two witnesses because their testimony is inconsistent with one another. And again, the trial court accredits the testimony of Ms. Roberts above that of her ex-husband, Mr. Kuhlman. And that's dispositive for this claim. The trial court's credibility determination should be given deference by this court and prevents a finding that she concealed information during voir dire in a manner that would be problematic. Lastly, Your Honors, dealing with this allegation that Ms. Roberts consulted extraneous information on her cell phone during trial. She is asked about this during the post-conviction hearing. Her testimony is that she doesn't remember doing this, that she, from her recollection, she did not do this. That she may have at some point said to an attorney talking with her about the case that was something she could have done. But Your Honors, in examining this record, what this court will see is that what Ms. Roberts is saying here is, well, I could have used the internet to do legal research, but that's not what happened. She does not testify as to having any recollection of actually consulting outside information. The recollection of her consulting outside information, as with the other issues in this case, comes from the testimony of Mr. Kuhlman. Mr. Kuhlman testifies that his ex-wife consulted outside information, that she did legal research on her phone during the trial. And were Mr. Kuhlman's testimony to be accredited by the trial court, defendant might have a claim for relief. The problem for defendant is that his witness, Mr. Kuhlman, was deemed not credible by the trial court. The trial court didn't believe what Mr. Kuhlman said. And that's really the long and short of this case, Your Honors. All of these issues at their core boil down to, does the trial court find Mr. Kuhlman and his numerous allegations of serious misconduct to be credible? And the trial court simply does not. These determinations should be given deference by this court and are the basis for a denial of relief to the petitioner in this case. So unless this court has any further questions, I will rely on my brief for the remaining issues and ask that the judgment of the post-conviction court be affirmed.
Thank you. Mr. Isaacs, you did not request any time for rebuttal as instructed by the court, but you have 2 or 3 surplus minutes, and I will afford you the opportunity to make a brief rebuttal.
Thank you. I apologize. I had mentioned that with the clerk, and when you said that as I was looking at my notes, slipped my mind, and I thank the court for allowing that. I want to be very direct and to the point. When I started my presentation, I indicated citing Adkins and Faulkner. In order to have a trial that's premised on due process, pursuant to the 14th Amendments to the U.S. Constitution, Article 1, Section 8 of the Tennessee Constitution, it is imperative that counsel have the ability to conduct voir dire with the intelligent exercise of challenges. And for my last remarks, I want to completely extract and redact the testimony of Mr. Coleman, because I don't want to go down the rabbit hole that this is a domestic relations case, and therefore we can assign one person's credibility over the other, because there are more significant issues. And when the state says this afternoon that Ms. Roberts did not fail to disclose her relationship with District Attorney Allen vis-a-vis the standard of Mr. D'Angelo, whose children played baseball, he described it as a passing relationship, and Ms. Roberts felt because, and if you say the because, she was a Republican operative, she was a campaign manager, she set up a campaign table, she worked the polls. Well, I will submit to you that any reasonable defense lawyer, if they would have had that information before them, would have exercised an intelligent challenge and would have moved to strike Ms. Roberts. But trial counsel did not have that ability, and that's not the law for Ms. Roberts to sit there and decide whether her relationship rises to the level of being disclosed. Now, again, excising Mr. Coleman from the equation, it's troublesome to me when the state talks about looking at legal issues on a cell phone, that it was kind of minimalized. And I think this goes to the heart of Robert's credibility. If a judge were to ask one of my jurors or me, did you ever violate my order about being fair and impartial and not watching TV, not talking to your jurors, not deliberating? The answer would be, if you're an integrous person, because I'm sure Ms. Roberts only sat on one case in the last decade, absolutely not. I mean, how many cases did she have to remember? And her response was, which is minimized, downplayed by the state, I think the wording I used with him, and that's DA Sanchez, that's something I could have done. So I could have disregarded the court. I could have been held in contempt. And the law is clear under Tennessee law, if you use extraneous information to do research during the trial, that there is a rebuttable presumption that the validity.
One might interpret that comment to mean nothing more than I had the technological capability of doing that. I could have done it.
With all due respect, and sometimes that's the dynamic of a transcript, and I could see how Your Honor could draw that conclusion, but I wish Mr. Sanchez hadn't gotten taken off the case after that comment, and would have been a part of the record. But regardless, if you look at the first issue, the relationship with Sharm Allen, and you talk about the duty under Tennessee law with Atkins and Faulkner to disclose, and you juxtapose that with D'Angelo, I mean, if I had to choose between the Little League parent or the person that campaigned for the district attorney whose husband's trying the lawsuit, I would have stricken Roberts well before D'Angelo. So,
you got one more minute. You have one more minute.
I would say there is, and for Coleman to completely disregard, I'm going to put him back in the equation, back in the mix. For us to completely disregard, and I'm talking about the royal us, his credibility, this man would have had to have made, because of the acrimony and vitriol of a divorce, very detailed, graphic perjury that was very specific to the facts in this case, respectfully, with the presumptions that our U.S. Supreme Court in Pena Rodriguez versus Colorado said when race and color are at issue. When we talk about using outside sources to do legal research, and this is a person that campaigned for the DA whose husband was trying the case, we would respectfully urge the court to find that this was not an impartial and unbiased jury, and counsel was not allowed the opportunity to strike Roberts. Thank you for your time and consideration this afternoon.
All right, thank you. Thank you. That concludes the argument in this case this afternoon. Thank you both for arguing the case today.
Thank you.
Court of Criminal Appeals is now in recess.